Ms. Suka. Good morning, Ms. Suka.
Good morning, Chief Justice. May it please the Court. I'm here representing the defendant, Calvin Carnes, Jr. As a matter of process, I think this Court is well aware that Mr. Carnes was represented at trial and on the filing of his brief by my then colleague, Shannon Trison, who has become a member of the Court, and I am here to argue the appeal. This is obviously a case that is troubling from start to finish. As the Court is well aware, on December 13th, 2005, 4 young men were killed on Bourneside Street in Dorchester in the basement of one of their parents' homes. The murders were brutal. They captured public headlines and a public outcry to find someone accountable. They were tragedies that were deep and searing for the families involved. Nothing in this appeal wants to or will undermine those realities. But this matter was troubling in lots of other ways. It was troubling in that, in this case, the criminal justice system, and I must argue, the court and the prosecutor, did things they ought not to have done to get a verdict, to hold someone, anyone, accountable. Now, it goes without saying that a defendant has a right to a fair trial and an uncoerced verdict. I submit to this Court that that right was not honored in this case, and that Mr. Carnes, who to this day maintains his innocence, who was never placed by physical evidence at the scene, who was not seen by the one eyewitness leaving the scene, who described the assailant, in fact, as white initially, and Mr. Carnes as African American. He maintains his innocence, and he did not get a fair shot here. The claims of error are many, and they extend through the trial. But for the purposes of this morning, I would like to focus this Court on the jury's deliberations. And in the deliberations, I would suggest that there were several errors that in and of themselves require that the verdict be dismissed and that there be a retrial, but that cumulatively, in the totality of these circumstances, absolutely oblige that result. The errors are these. First, it was error for the deliberating court, the deliberating judge, to ignore evidence of a deadlock, as though to ignore 5 separate notes from a jury that indicated unequivocally that they were hopelessly, immovably deadlocked.
Okay, but don't you agree that every time a new juror is placed on a jury, that becomes a new jury, and the jury is told to commence again their deliberations?
I will deal with that. Perhaps, Your Honor, is the right answer, I think, in that circumstance.
Why is that not relevant here? You've got jury 1 begins deliberating on Friday, June 6th. The deadlock note comes at 3:20 on June 12th.
To be sure.
Later that afternoon, just before 4 p.m., the judge dismisses the 2 jurors. So a new jury then starts the next morning. Any problem yet?
Your Honor, no. That's why I say perhaps. In the context of this case, and if you want, I can address this error specifically right now. I was going to suggest the full list, but let me address this issue. This is a case where there are 5 notes of deadlock, to be sure, over a period of two differently constituted juries, if you will. The jury deliberates for nearly 30 hours, right? They start on June 6th upon instruction of the judge. And I want to turn to that instruction at a moment, but to deal with the deadlock issue. They go until June 12th at 3:50.
20. Okay.
20, thank you. And they come back with a note, and they say that they are deadlocked. And the note is...
But all this is irrelevant because we have a new jury the next day. So what happened before the new jury doesn't count.
Well, and this is the perhaps, Your Honor. It is it is, I think, an important statement of the law that we must make sure when a jury starts deliberating anew that it is truly anew. And that statement, which actually the appeals court had dealt with just a month before the Carnes trial and Commonwealth versus Olivaria. And in that case, if you look at footnotes 10 and 11, you will see that the court contemplates how seriously you have to take your job as a judge to make sure that a long deliberating jury truly starts anew. Now, defense counsel did not object to failing to call a mistrial or even a deadlock on Thursday, June 12th. The new jury was deliberating on Friday morning. I note that on Friday morning, on Friday morning, the foreperson of the jury expresses concern about the length of the deliberations given her residency, and the court deals with that on Monday. On 350,
Given her what? I'm sorry.
her residency. She was a
All
resident.
right, I didn't understand that.
And at 350 on the 13th, and this is the appendix at 87, the court says the jury writes another note, and that second note says the jury is firmly deadlocked. Each member has made a firm decision regarding guilt or lack of guilt for each charge, and consensus is not unanimous. Now, the court says to the parties, you know, they have only been deliberating a certain number of hours. I'm going to let them go home and think about it. And we will deal with it on Monday. And I'm inclined to tell them to continue deliberating because they have not been deliberating a long time. Defense counsel does not object to that. And she admonishes the jury not to talk about the case, not to think about it, not to confer with one another, not to do anything over the weekend until she has greeted them on Monday morning. On Monday morning, and the transcript is very clear on this, on Monday morning, before Judge Hinkle greets them, because you will recall that the trial judge was Judge Brady, and on the 12th, Judge Hinkle took over for deliberations due to a medical emergency. So on the morning of the 13th, before they are greeted, they get another note. And this is why, perhaps, they get another note. And then the note, written at 9:30 in the morning, before they were supposed to have done anything, says the following: the addition of 2 new jurors has not changed the position of the jury. At this point, all but 1 juror is in agreement that there is no hope that 1 juror changing their mind. We now know that the holdout juror is a woman, began feeling verbally abused on Friday and is very upset. Also, could you call my job? That's the young woman who was the foreperson and the resident. Now, what we know by this note, and what's troubling, are a number of things. 1, at least this jury foreperson didn't follow the orders of the court because she said, don't do anything until I greet you. 2, she didn't follow the rules of the court because Judge Brady was abundantly clear that I do not want to know any numerical divisions, ever. Don't tell us. It is not our right. It's not our position to know. That's violated. 3, we know that the holdout's a woman, and the jury was relatively evenly split at this point. And 4, we know that there's tough stuff going on in this jury. That seems to me a recipe for a very different handling than the cases that often come before this court and others, which is a jury sort of uses the vernacular, look, we're deadlocked. By the way, could you give us further instruction on this? Look, we're deadlocked. Is it okay if we use the blackboard?
Okay, but immediately after that is when the issue comes up with regard to juror 48, and juror 48 is removed from the jury.
Well, it actually takes a little bit of time.
You're right. I'm sorry. That's Monday. It starts, and then we have a second deadlock note at 4 p.m. And then again at the end of the day, and then before the jury starts the next day, you've got the issue with regard to that juror.
We actually have 3 expressions of deadlock during the 16th. The next...
I'm sorry, 3? We have...
Now, on the 16th at 11:30, on the 16th,
Right.
Ms. Friesen asks for either a Tui Rodriguez charge at that time.
Is there something that happened near 11:30?
No, I'm sorry. At 10 o'clock in the morning, Monday morning, she asks for one of 2 things. She asks for a mistrial or a Tui Rodriguez charge.
Is this before the jury has come down?
Yes, when
After the
dealing
note,
with
but
this
before-
first note on Monday morning, she asks for a mistrial or a Tui Rodriguez charge. The court says, I'm not inclined to do that right now. Off they go. At 11:30, there's another note. That note says, one juror has expressed a concern that continued heated debate will cause a flare of her medical condition. This type of heated debate would be required to make progress in the deliberative process. We are still at a deadlock. At this point, Ms. Friesen renews her motion for a Tui Rodriguez charge or for a mistrial.
But is that note the type of a note that says we're at a deadlock, we need help, or whatever, what's usually a deadlock that necessitates a Tui Rodriguez charge? Isn't that we're still at a deadlock because this juror is concerned about a flare-up of her medical condition, and if there are heated discussions, and we're going to have heated discussions, we're at a deadlock.
Well, that may have called for, Your Honor.
Excuse me, we're going to have heated discussions because we're at a deadlock.
That may have called for an appropriately balanced Tui Rodriguez charge. The concern at this juncture was that we already knew it is an 11-to-1 split. And the case law here federally is abundantly clear that at the moment when you know there's a holdout, there's one dissenter, you must be enormously cautious about how you proceed because you cannot be seen to be coercing a verdict through the courts.
And isn't that what the defense always claims that Tui Rodriguez does? It coerces a verdict.
Well, a modified Tui Rodriguez charge needn't if it is said carefully that one needs to respect the views of the dissenting jurors, one needs to respect the views of the majority. And what is troubling in this case, and this court has talked about essentially the silent communication. The Ninth Circuit called it a long time ago a de facto Allen charge, the discredited old Allen charge. What's very troubling in this case is she simply says, keep on deliberating, keep on deliberating. She doesn't do anything to assure essentially the safety of that dissenting juror. And that is why the courts have modified Allen and modified Tui out of an understanding that you must present a balance. And a fortiori when you've got one and you know there's one. Because we must make sure that we're not involved in ganging up on the dissenting juror who is, after all, the bulwark of what this system is about.
Could I just ask you one
Sure.
question? I thought you said that on Monday, the first thing in the morning, that there was a sense that the jury was evenly divided. Is that what you said?
No. Monday morning, we know that there's one holdout. Monday morning, we know
Evenly
that
divided,
there's
men and
one
women,
holdout.
I think Justice Botsford.
Oh, I see.
One juror are in agreement.
Okay.
So Monday morning at 9:50, we know there is one holdout. We
Okay.
know it is a she, and we know she's feeling abused. At 11:30, there is a comment about the medical condition, and by reasonable inference, not by a fair certainty, but certainly by reasonable inference, in terms of the way that note's written, the medical condition is the holdout. We then find out who the holdout is, and the holdout is juror 48, seat 15.
I'm
And
sorry,
she comes out.
you say you knew that. The judge herself said in her findings that she did not know who the holdout was. She made
surely
a specific
does.
finding.
She surely does. She says we have no information as in for a certainty, but that's not the standard. The case law is abundantly clear.
Okay, well, what do you say is that information which was so clear that we should disregard the judge's finding that she did not know who the holdout was?
Your Honor, this is, I think, what makes it very clear. The juror comes out. She is asked about her medical condition. She says she doesn't even know a note was sent, that she's fine, that she's willing to continue deliberating.
Well, she says
She
she has
says
she She says she has lupus,
To be sure.
so she has a medical condition.
To be sure. But she says she did not know that the note was sent. And I will urge you to look at Judge Brady's instructions. It is pretty clear, although he doesn't say the jury must confer on all notes being sent out. He does say the jury as a whole will communicate with me through the foreperson. And there is an indication here that she didn't even know. Now, I will agree with you, Justice Gantz, that we don't know that she's the holdout. We have information now because she's talked in the press. We didn't know that she was the holdout at that moment. But I would guess that the standard is there a reasonable suspicion? Is there a risk? There surely was a risk of that at that time. There surely was a risk.
I'm sorry, so I'm confused now. So you say that there surely was a risk that the juror who had this medical condition was a holdout, and therefore the judge should have done what?
At a minimum, should have given the Tui Rodriguez charge, given them one more return pursuant to 23434. And then when the jury came back that afternoon with further deadlock on the 16th, a mistrial must have been declared. 23434 is there to guard against a coerced verdict, guard against a judge saying, just go back, just keep on going, just keep on going. The notion of one return upon a deadlock, to be sure, the court has discretion, but it isn't unfettered discretion.
Okay, but a judge doesn't have to give the Tui Rodriguez unless he or she finds in her discretion that there's been due and thorough deliberation. And we have a jury that started Friday morning, and now it is Monday midday. So they've deliberated for about a day and a half with this new jury. Is she not entitled to find that that was not due and thorough deliberation because it's been basically only a day and a bit of a morning?
I think under the circumstances, she was not entitled to that finding. The note on Monday morning says the addition of 2 has not changed the position. Her instruction also does not comport with the instruction in Commonwealth versus Oliveria. And I would urge upon this court a careful review of that decision, because what it says is when a jury has been deliberating a long time, and this seems to me a wholly reasonable proposition, and it's taken them 30 hours, and they've sorted through evidence, and they lost 2 jurors, you must make sure affirmatively, not just, you shouldn't just say, please start anew. You should say you must disregard everything that happened before. Everything that happened before. And I would note, although it's just something I noticed, that on 6/13/08 at 10 a.m., when the jury forewoman said she couldn't continue to serve on the jury, there's a crossed out bottom part of the note that says, could we use sheets by which suggests to me that there's a question of whether they're using the materials from the previous juror, from the previous jury. She did not, Judge Hinkle did not instruct this jury that they must disregard everything that happened before and start anew. That becomes particularly important when you know there's one holdout. She did not do that. She didn't ensure that this was an untainted, completely new deliberation.
Was there any objection by defense counsel? Was there any claim? Did defense counsel say, Your Honor, I wish that you, in view of that note, instruct the jury specifically that they should start again and disregard all the whatever charge they may have prepared and begin afresh?
She did not state it in that fashion, but, Your Honor, she did raise concerns about improper deliberations among the jury. Now,
excuse me, is the citation for Commonwealth versus Oliveira in your brief?
It will be in the supplement that I provide. I must address for a moment, please, the question of the application of cousin in this case. And let me simply say that it does not belong here. This court very carefully stated in cousin that it would not set up a protocol unless it was necessary. This case screams for it. In this case, there was a juror whose separated husband had a record. The Commonwealth over a weekend trolled around in police reports and in his records, his court records, his police reports. During this very weekend, They
But
didn't
wasn't
say
that because,
something to
but
the...
wasn't that
excuse me.
because someone, the victim witness advocate, came to the prosecutor and
sure, but
said,
what is
I
troubling
recognize
here-
this juror as someone who has, you know,
Yes, Your Honor.
yeah.
We are not saying that the information, we have no information to suggest that the information coming to the prosecutor was improper, but what he did with it was entirely improper. He
But
did not
once he
notify
knows
defense
that
counsel.
But once
He did not
it
notify the
indicates
court.
that, doesn't that indicate that this person has misrepresented something on the questionnaire?
I will ask you to look very carefully at the jury empanelment. There were people seated on this jury who had not properly filled in the your experience with the law section of the questionnaire. Judge Brady specifically said, I don't really care. Getting people off because they were victims of the crime is of no moment. In the cases cited where you get a juror off during deliberations, for material misrepresentation on the questionnaire, it is, for instance, a drug case where the person has a drug conviction. That is not this case. I have looked expansively and have not found any case where the long separated husband's record becomes an emergent or compelling reason to get
But the reason
someone
that
you
we
might
ask-
suspect is the holdout jury off a
But
case.
the reason that it's even permitted that the person be removed is not because of the conviction is similar to the one on trial or anything like that. It's because the person has made a misrepresentation to the court under oath.
It's not under oath. It's risking. I mean,
It says it's signed.
it's signed.
Right,
But
under
Your Honor,
penalties of
with
perjury,
if
and
you
the
look
court
at
has
the
asked
voir
the
dire-
questions.
I'm sorry.
The
I'm
court has
sorry.
also asked the person questions in court.
In this case, and I've given the court the questionnaire. The questionnaire at issue here, and the judge makes findings that are frankly erroneous. Among other things, she makes a finding that I have just provided that to the court. It was not in my good sister counsel's appendix. It will be at page 121.
It's repeated at length in the Commonwealth's brief.
But it is the visual of the questionnaire that will be of assistance to you.
No, we know that.
The visual of the questionnaire is that she says that he is her husband. She says that they are separated. She knows nothing about his employment history. She begins to answer yes, scratches it out, begins to answer yes on arrest, scratches it out. The judge says she tried to delete. She couldn't delete. She didn't delete. She could have stood up and gotten a new form if she wanted to misrepresent. She didn't. And no one asked about that in impanelment. To your point, Justice Cowan, no one asked. The questions were general. There were others who were seated who did not fill out your experience with the law section properly. They were asked. Some were seated. Some were challenged by the defense, some by the prosecution. To remove a juror in this particular circumstance, after hours of deliberation, problems knowing that the jury is not following the directions of the court, a suggestion that they are trying to move her out with her medical condition, and then you remove her, the court risks sending a message that that they didn't approve of that juror's view, they approve of the majority's view, number one. And number
Ms.
two, I
Zucker,
must say...
I have to interrupt you. You
I'm
are
sorry.
running way over. You can answer the Justice's question, but not go on to another one.
I was trying to get it all in. I thank you for your time.
Thank you. Good morning, Mr. McGowan.
Good morning. May it please the Court, David McGowan for the Commonwealth. With me this morning is Assistant District Attorney Josh Wall, who is the trial prosecutor in this case. Judge Hinkle exercised her discretion appropriately, and she removed a juror for deliberately omitting material statements in her juror questionnaire and exercised her discretion properly in choosing to discharge this juror under her statutory authority. There was no impropriety at any stage of this deliberating procedure, how it was handled by any of the parties. And further, what occurred here was justice. A juror had made significant omissions and misrepresentations in her juror questionnaire, and during her voir dire, she revealed even further that
This was the new questionnaire that makes it easier for the juror to understand the questions. Is that right?
That's certainly the Commonwealth's position that it's easier, and this Court noted in Cousin that where Cousin created arguably a difficult jury instruction to complete fully. This is a new, very express questionnaire that is reproduced in the Commonwealth Supplemental Appendix at pages 175. In that regard, there are a number of boxes. The third section of the juror questionnaire requires prospective jurors to explain their experience with the law. Have you or anyone in your household or family ever had any of the following experiences with the law? That's the central component of this questionnaire that's at issue. And Judge Hinkle made factual findings in the June 17th transcript, pages 62 to 66, where she found a number of misstatements, a total of 8 omissions that do not just concern her husband. Those omissions concern herself, the juror herself. She had been a witness in a case. Her husband's federal criminal case, she was a witness for the defense. She never explained that she had been a witness in the sense that she sought and obtained restraining orders. She herself had filed numerous lawsuits against tenants at her properties throughout the New England area, and that she herself had been a victim of a crime. None of those things personal to her were revealed. In addition, the questionnaire that she filled out, she indicated that her spouse or partner was the individual with a lengthy criminal record. She did not.
Mr. McGowan, you list the judge's orders, and what I haven't taken a look at is the voir dire of this juror at this point. And in essence, what was the juror's explanation for the failure to list these many involvements with the legal system?
Well, that voir dire can be found on the June 17th transcript from pages 38 to 59. In essence, every time the judge asked this juror, well, what was your understanding of have you been a victim of a crime? She would respond something akin to, I thought it was, did I perpetrate a crime? And things along those nature.
Okay. Was she appointed counsel at that point?
She was not. She was advised that she didn't have to answer any of the questions at the beginning of this voir dire. Okay. And both counsel and the trial judge were meticulous in phrasing their questions to avoid any of the concerns noted in this court's opinion in Cousin.
Well, I mean, in fairness, she also said she's been separated from this person for 3 years and she hadn't seen him, and she no longer considered him to be part of the household because she hadn't seen him for a long time.
To the extent that can be given credence, even though the judge found that her explanations for much of this to be incredible and dishonest.
Well, I don't think she found that to be incredible. She may have found other parts to be incredible. But I don't think she claimed that she was still living with this gentleman, did she?
She didn't expressly credit it at all, but she did say, I find all of her explanations to be dishonest. And that was one of the explanations. I didn't think he applied.
Well, what did this juror say in response to Judge Hinkle's questions about why she didn't report that she had been a witness in her husband's criminal case?
Her answers varied, but they skirted around the question, and they gave, I thought you meant something else. And they were incredible on their face, and I would encourage the court to review that voir dire. It's essential here.
And yet this woman, do I take this woman you say was a landlord who had tenants somewhere?
That was what she said. Again.
So she wasn't a totally illiterate person?
No. She had 2 degrees, as I recall. She was a nurse or a licensed.
That is correct. She had
so
2
she was
associates.
asked if she had been a witness, and she said she didn't understand what that meant.
The judge found her explanation for her difficulty with the questionnaire to be completely dishonest, and she did find, in addition to the misstatements, that English is her first language, that she has an educational
She's from Ghana, is that right? From Ghana?
Apparently from the record, yes. One of the degrees is from Ghana. The other is from a local educational institution in Boston. The judge found that not only the same judge that was in Cousin found that this questionnaire was clear in what it demanded. She found that the juror could have understood the requirements that she was under when filling out this form. And further, she found that Judge Brady's initial questioning during impanelment gave an additional burden, where he said some jurors misfill out this form. If any of you think that you may have done so, you can raise your hand and we can address that. 9 jurors did raise their hand, and 2 of them were discharged as a result of that questioning. So this is something that the jurors certainly understood, and that Judge Hinkle found that this particular juror did understand and intentionally, albeit for whatever reason, but intentionally chose not to make those statements.
Mr. McGowan, I take it that one of the claims of the defendant here is that it was happenstance. It was a victim witness advocate, I think, who drew this to the attention of somebody who then drew it to the attention of the prosecuting team, and that rather than informing the judge at that point that there was a problem and the judge is then in control of what then happens, that the Commonwealth did its own investigation, about this witness. And the question I have for you is, when that information comes to the attention of the prosecutor, let's assume it's in a case where it's a different case, the jury's not deadlocked, the Commonwealth just now has the information. Is there an obligation on the Commonwealth to bring that to the attention of the judge at that time, before the Commonwealth has done any other background investigation?
The earliest practical moment, I think, is the obvious requirement. In this case, to not confirm any of that information would have just resulted in a delay. Here, this information the prosecutor became aware of this information at the close of business Friday, and this was brought to the court's attention before the juror was voir dire concerning her medical condition was given to defense counsel and the judge to be taken up. The prosecutor. No,
my question is a different one. I mean, had the business closed on Friday?
Yes.
So that the court was in recess when this information was brought?
Correct. And
it was brought to the court's attention the very first thing Monday morning?
Not the very first thing. The very first thing, when the jurors arrived, there was a note prior to deliberations, and the parties addressed that note. The prosecutor then reviewed the documentation supporting that suggestion. That the two bits of information were that when he learned of this information, he asked this juror's name to be run through the Boston Police database to confirm that there was a domestic violence allegation. That report indicated that the perpetrator was her husband. Then the record check of the husband revealed that there was, in fact, a case brought in the Dorchester District Court confirming what the victim witness advocate had said, but then also indicating a number of other crimes, particularly a recent and dramatic experience with the law, his 40-month federal sentence for fraud. Those documents were given to the parties after the prosecutor reviewed them on Monday morning before the juror came down with the medical situation. That's clear from the record, and defense counsel acknowledged that on Tuesday the 17th at page 28 in the record. I received this information before we knew which juror had the medical condition. So the sense that there was a holdout and that the Commonwealth was seeking...
My question was directed beyond this case, because we know that there are such inadvertent disclosures from time to time. It's not that it came through a victim witness advocate, frankly, doesn't surprise me, but it could be, a police officer recognizes somebody on the jury, or a member of the family of the defendant recognizes somebody on the jury. And my question is what is the obligation in those circumstances of either party, defense or counsel, to bring that to the attention of the judge, even though the trial just seems to be going along just fine?
I think the earliest practical moment.
You're saying there is an obligation?
An ethical obligation. If it's something that either the parties think is of significance to bring to the attention of the court, this could, of course, each of these cases will arise differently, and each judge, as they're faced with this, will have to exercise the discretion to weigh what the alleged falsehood or omission was, whether it was innocent or has greater significance, to be balanced with how it was described. I think the framework of giving trial judges a way to balance this as this arises is really the only workable framework.
I think what the Chief Justice is driving at is should the prosecutor run the record before telling the judge? Not in this case when there was no time between Friday and Monday. Or should the prosecutor first tell the judge and then get permission to run the record?
That's one piece of the question. I'm really asking a broader question that goes to defense and the Commonwealth. It might be that somebody says, I recognize that person on the jury. Nothing more. I know that person was involved, as a defendant. Let's take the very worst case. Family member comes to, testify, testified on behalf of the police or some other kind. Well, I know that person is cooperating with the police. Does the lawyer at that time have an obligation, without doing any further checking, to inform the court of what a piece of information that has now inadvertently come into the... I'm talking about the counsel, qua counsel as office of the court, not as prosecutor or defense attorney.
I think there is. I guess I'm having trouble identifying the moment in time, whether time freezes and either the party needs to address this with a stoppage in the proceeding or not. If defense counsel learns in the morning by a witness leaving that, hey, one of your jurors is a police detective.
You wait for an appropriate time, but before you go doing an investigation, right? That was my question. Not do you have to do it right that second, but before either party then commences its own investigation.
No, I don't. If I understand your question correctly, Your Honor, the Commonwealth does not need to seek the court's permission to investigate what could possibly be a crime here of misrepresenting and deliberately omitting things. Is it a crime in the Commonwealth? The Commonwealth, of course, would not have to seek permission to investigate.
I'm not suggesting that.
No, so there should be, at the earliest practical moment, if either of the party learns that there could be a serious issue with the impartiality of the juror, an obligation to disclose that and to work together to resolve that. And if defense counsel learned of an impropriety and doesn't have the means to confirm or dispel that, the Commonwealth would never refuse to work together to resolve that and ensure an impartial jury for all the parties.
But the Commonwealth here did more than that. The Commonwealth ran the names of all the jurors through the Boston Police database.
Correct.
Why was that done?
They did that at the beginning, didn't they?
No, that was done after you learned of this particular juror. Somebody said, let's run all the jurors through the police database.
Correct. At the outset, all the jurors' criminal records were run. This juror, of course, nothing turned up because she does not have a criminal record. When the database search was conducted,
This is more than a query. This is more than a query search, I gather. This is a name check through the Boston Police Department database.
Correct. It shows whether you've called 911 or you've reported a stolen wallet, things of that nature. When it was run on one, the prosecutor felt ethically bound to want all the jurors to share that with the court.
That was the import of my question, frankly, which was when something like this is brought to the attention of a prosecutor or defense counsel, is it not more appropriate to immediately tell the judge? When I say immediately, I don't mean stop the proceeding. I mean at the lunch break, at the afternoon break, before the end of the day. There are lots of ways that you can say, Judge, a matter has arisen, and then have the judge decide what is appropriate in those circumstances. Now, that has got nothing to do with whether the Commonwealth has a right to run quality checks or to investigate or do whatever it is, but isn't that the more appropriate way to ensure that you really are working, as you say, collaboratively with both parties, and neither party gets, has unequal resources to bring to the attention of the court? There may be, don't know that there is, there may be a problem.
Sure, that's certainly not an inappropriate way of this being conducted, but it does not mean that the converse, that if the defense attorney or the prosecutor confirms the information before they bring it to the court, that that's somehow improper in all instances, especially
I'm not looking for that, Mr. McGowan. This is a situation which is arising, and obviously we are now in a somewhat different era because we have access to many databases, and the databases aren't just Boston, they're across the country and across the world, and so that it's an issue that is coming up before this court. So I'm simply asking for you to say, would there be a problem with that? And I hear you saying no. It doesn't imply any. It doesn't imply the opposite. It just says, as we try to work through these procedures, what should happen?
Certainly, if that is how it plays out, that of course is appropriate. However, that shouldn't be. I would encourage this court not to limit that these situations are dealt with and only in that particular way. If things are easily confirmable and verifiable, as this particular instance where the Commonwealth searches its own records, in essence, documents in its own care and custody control in a very expeditious manner, it didn't result in a delay in this trial. I think you're going to find some of your colleagues might be a little concerned if we said that all of the Boston police records were in the custody and control of the prosecutor. And that's okay. Point noted, and I retract to the degree that it was that far-reaching, but the point was that it can be resolved very quickly and not cause any undue delay in the proceedings in any way. If defense counsel learns that one of the jurors may have been an old retired police detective, and one of his defense bar colleagues mentioned that to him on the way out of deliberation someday, sure, and he picks up the phone that night and calls down to the police headquarters and confirms that information and arrives in court the next morning saying to the parties, I just learned this, how should we proceed? The fact that he verified that information to a limited degree does not infirm or imply any kind of... Now, am I correct that the quality checks were run on the jurors before the jury was seated? Correct. So the checks that were then run on all of the juries were beyond a quality check. They were mining through all of the Boston Police Department files?
I think
mining is not a fair
No,
term
I mean
to
just
use.
canvassing.
Plugged into the system and what they turned up. I don't.
But
my
not
understanding is-
Corey records.
No, completely separate from Corey. This would be
Okay.
almost the opposite. When folks are victims of crimes, as was the catalyst in this particular instance, calling 911 or reporting a stolen wallet, or having any interaction with the Boston Police Department. This was all entirely appropriate, given the gravity of what occurred, and Judge Hinkle did not.
I'm sorry, is it your view that it would be appropriate for the DA's office to do police database searches of jurors during the course of trial without speaking to the judge?
I don't think that. First, I don't think that's inappropriate on its face. It's not prohibited by law in any way, but it certainly isn't a practice or even feasible to do in many cases, and not necessarily helpful. And say a prosecutor did that, and that tone with
Why was
catalyst.
it helpful here? I know why you searched that particular juror. Why was it helpful here to do a database search of all the jurors?
Because it verified what the victim witness advocate said. So it was a quick way to verify.
That's as
on
to
that-
one juror.
But you did
Not as
a
to all.
database search.
Not as to all of them, not as to all 12 of the deliberating jurors.
Well, in the sense that it could have raised, well, it confirmed that there wasn't a greater problem. They didn't know what they were faced with in this particular jury. They had one juror who clearly had made intentional misrepresentations. They didn't know what else they had there in that jury box. They dispelled any suspicion of any possible other partiality on behalf of this juror, and when this partial juror was removed and replaced with an impartial alternate, there now has a jury
Do you think
that's...
it'll have any impact on people being willing to serve in jurors if they know that one of the things that the prosecutor is going to do is run complete database searches on them? And there are lots of linkages between one police department and other police departments and federal agencies.
I understand Your Honor's point. I think that's just simply not something that would occur in great abundance. It's just simply a question of resources and need. In this case, it only came up, not because it was something on due course, it only came up because it was brought to the prosecutor's attention.
Could I ask you, though, two questions about that? Number one, the fact that the victim witness advocate said, I helped that woman in a matter in Dorchester District Court or whatever. Did you know, or did somebody know, oh, I know she didn't write that? I mean, how did you connect? What was it about that information that made you think, oh, my God, we've got to run all these records?
That's not... The prosecutor, when told that information, didn't recall during impanelment and having any of the seated jurors have that type of experience, especially when within Suffolk County, and that it was a year before, and that recently.
Okay.
So that was an immediate trigger that something wasn't disclosed. Review of that questionnaire certainly wasn't disclosed.
All right.
And then he took 2 steps to verify that information quickly and immediately brought it to the attention of the parties on that Monday.
And then the second question is, okay, so you're going to review her records, but what was the justification for running the database on her separated husband?
To confirm that, first, the database confirmed that she had made an allegation of domestic violence against her husband. Then they ran the husband's record to confirm that a case was actually brought in court. So it's 2 small steps that confirmed the victim witness advocate's statement.
And to confirm that she had misrepresented on the questionnaire.
Indeed. And what that did was open up a different situation where the husband, in fact, had a dramatic and recent involvement with the federal justice system, serving a 40-year sentence. So it created what was small at first into a significant situation, and her voir dire revealed even further information of her dishonesty.
If I could have one short question. Usually at the conclusion of when the jury is selected, the judge says, please return all the juror questionnaires to the clerk. Did that happen here?
Presumably, this particular questionnaire became an exhibit.
I know, but did the ADA have that questionnaire, or was it returned to the clerk at the conclusion of the jury selection?
I'm not sure. I may have misspoke in terms of the consulting the questionnaire. What the prosecutor did recall was that this was not something that was disclosed at that time. So I don't, to the quick question, I don't think that was in hand at the time.
And what you're saying is that at the time that you did this, there had been no indication as to A, there was a holdout juror, or B, who it was?
That's precisely clear from the record. The note on Friday afternoon, shortly before this information came to light, was that the jury's firmly deadlocked. Each member has made a firm decision regarding guilt or lack of guilt for each charge. All this confirmation process occurred over the weekend, and the first time there's an indication that there is a dissenting juror is on Monday morning, after this information had already gone through the pipeline.
I'm sorry, one last question. Does our record reflect how many female jurors there were on the deliberating jury?
I'm not sure.
Didn't the defense counsel just said that was the question, that they were evenly split, men and women?
I didn't seek to
That's
do
what
a
she said.
gender breakdown. I didn't see that, but I have no reason to discredit that statement.
Thank you, Mr. McGowan.
Thank you very much, Ron.
All right. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices, and the